All right, we're going to go ahead and get started. Welcome to the Innovation Business and Law Center's speaker series. I'm Jason Rantanen, professor at the University of Iowa College of Law and director of the Iowa Innovation Business and Law Center. Now, ever since I've been a history student, first at Brown and then at the University of Chicago, I was struck by the ways in which race has become embedded within modern social and legal institutions, both through the scientification and systematization of European treatment of its peoples, as well as through the more organic growth of government and society in the United States. Uh, from the forcing of Native Americans to ever smaller, less bountiful land, to the enslavement of people kidnapped from Africa, to the disparagement of Latin Americans, to the exclusion of Chinese Americans, and much more. Explicit and implicit acts of inequitable treatment based on skin color and ancestral origins weave through the history of the United States. Nor is the racism in the United States any less institutionalized and structural for its organic growth. I mean, just as an oak tree can grow organically, so too does it adopt a form and structure. Understanding that form and structure has value. It can tell us, for example, when a branch might be rotten and subject to fall in the next storm. Similarly, studying the ways in which race has become embedded within our legal system, both implicitly and explicitly, can help us understand how to, in the words of the US Constitution, achieve a more perfect union. People aren't perfect, but we can always try to do better. This fall, the Innovation Business and Law Center's speaker series brings together 7 talks with the collective goal of better understanding systemic and institutionalized racism in innovation, business, and law. Our first speaker is Professor Keith W. Robinson, who is the Altshuler Distinguished Teaching Professor and co-director of the Sci Center for Law, Science, and Innovation at the SMU Dedman School of Law. Professor Robinson received both his Bachelor of Science in Engineering and JD degree from Duke University, and he practiced law in Washington, D.C. for several years before becoming a law professor. He's published in numerous journals, and in addition to teaching doctrinal courses in intellectual property law, he also teaches a course on designing legal apps in which student teams partner with legal aid organizations to develop legal software applications to improve access to justice. Today, Professor Robinson will be talking about the United States Patent Office's use of artificial intelligence, both now and what might happen in the future. And while the use of artificial intelligence can offer many benefits, especially efficiency, it comes with negatives as well, particularly the potential to make the patent system less accessible for underrepresented innovators. But with this peril comes opportunity, the potential to design a system that's better and more equitable than what we currently have. Professor Robinson's going to talk for about 30 minutes, and then he'll answer some questions. So please type your questions into the Q&A function in the Zoom webinar, and I'll call on people in the order that the questions go in. Ideally, we'll have you ask your own question using your own voice and unmuting your microphone. But for now, we're going to turn it over to Professor Robinson to hear about access to the patent system.
Okay, are you seeing the slides?
I am seeing the slides. They look good.
Okay, perfect. Thank you. All right, so thank you to the Innovation Business and Law Center for having me. I'm excited to talk about this project. More importantly, I'm excited to be a part of this conversation. I think it's a conversation that we need to have, and one that will hopefully lead to some fruitful outcomes. And so the purpose of this project is to explore the use of intellectual property, and in particular, the use of the patent system. And in thinking about the use of the patent system, one idea that I've been wrestling with is that in order to effectively use this system, it first has to be accessible. Innovators need to have access to the patent system. And so this is what this talk focuses on, in light of recent interest by the USPTO, which is the government agency that grants patents in the United States, in light of that agency's interest in artificial intelligence. And so my thesis is this. I don't think that the patent system is accessible, and I think that AI threatens to make the system less accessible. And what follows from that is a series of questions then. Well, what are some best practices that the USPTO could implement when it's using AI to examine patent applications? Should we place some sort of limits on the use of AI in assisting inventors in creating inventions? And then finally, how can artificial intelligence be used to help underrepresented innovators? And so these are the points that I want to have a conversation with you about today. Some of you might be asking, why do we need this conversation? Well, if you go on the USPTO's website and click under initiatives, they have two major initiatives at the agency currently. The first is artificial intelligence, and the second actually has to be expanding innovation. And when the USPTO talks about expanding innovation, they're talking about patent accessibility. And so what I want to do is I think there's a gap here in that there's no discussion about, well, how will artificial intelligence actually impact the expansion of innovation? And this is where this project and this talk hopes to fill some of those gaps. So first, let's look at some motivation for this research. Why do I think that the patent office or the patent system is inaccessible? Well, there was a recent study funded by the Information Technology and Innovation Fund that reveals some alarming statistics about the participation of women and minorities in the patent system. And a lot of motivation for the beginning of this research comes from some revelations uh, that were garnered by the study. So first, what the study found is that less of 8% of U.S. born innovators are minorities or non-white. In addition to that, and this study also uh, explored the level of innovation across different scientific domains. And here's a table from the study describing the demographics of U.S. innovation. And as a black patent attorney that practiced for several years, it was anecdotal, but what this study really brought to light was the alarming number of Black or African Americans that are participating in the patent system. And you can see that the number is embarrassingly close to zero, at least in this particular study. The number is embarrassingly close to zero for Black and African American innovators. In addition, the studies found that only about 12% of US innovators are women. Now, there's been some discussion about this, and there have been some recent studies with recent data to say that this number is in fact increasing. And then, in fact, on the USPTO's website, they do report that the numbers are increasing, but really not by that much. So, for example, the USPTO found that at the end of 2019, the number of patents with at least one woman inventor increased from 20.7% in 2016 to 21.9%. The woman inventor rate, which is defined by the USPTO as the share of US inventors receiving patents who are women, increased from 12.1% in 2016 to 12.8% in 2019. So yes, while that number is increasing, if you compare it to the number of women in the US population, it's still relatively low and a slow increase. In addition, this study found that the average uh, the average age of an innovator was 47. In other words, the study found that the majority of innovators had obtained a college degree, and more than half of them held a PhD. And this somewhat refutes the myth that all the innovation happening in the US right now is being done by young people in Silicon Valley. In addition, the study found that 60% of innovators did so in a company setting. In other words, that they were employees of a established company, and they were able to use the resources provided by that company, whether it be research and development, uh, money, other resources, employees, etc., to complete their innovations. In an Iowa Law Review article, Professor Michael Risch also found that the patents filed by individuals as opposed to people in companies were more likely to be invalidated during litigation. So based on the results of this study and others, you have to question, well, who is it exactly that the patent system is leaving behind? It would seem that those people would be women, minorities such as Black inventors, solo inventors, and small or solo enterprises. In the ITIF study, it put forth a number of proposals, and a lot of those proposals are related to the idea that all of this could be solved by improving the STEM pipeline. In other words, let's get more women, let's get more Black innovators interested in science and technology at an early age, and we will see this number increase. And I think that that is true. But what we have to understand is that the pipeline problem is only one part of the equation, and there are other systemic problems at work here behind the scenes. So one of the key questions then that I want to answer in this project, in this talk, is to try and understand how the USPTO's adoption and interest in artificial intelligence is going to impact patent accessibility. And what we've seen over the past year and a half is that the USPTO has grown very, very interested in artificial intelligence for a number of reasons. And so the top quote here on the slide is from a January 2019 speech where the director of the Patent Office, Director Ayanku, talks about being able to leverage artificial intelligence to perform patent examination at the Patent Office. One of the reasons or one of the rationales given for this interest is that it will help the United States compete and continue to be a desired location for innovators, not only in the United States, but across the globe to file their patent applications. In addition, in a request for comments that was issued by the Patent Office last year, the Patent Office was interested in learning how should it treat inventions that were created by artificial intelligence or inventions that were created with the help of artificial intelligence. And so these are the two main ways in which the USPTO seems to be interested in how artificial intelligence will impact the innovation landscape. So why is this a concern? Why should we be worried about this? Well, we know from other domains that contrary to some initially held beliefs, AI can make biased decisions and lead to biased results. And this is primarily due to the fact that humans are the ones that create AI, And intentionally or unintentionally, those biases are passed on to the artificial intelligence. In addition, artificial intelligence may train on biased data. So, for example, there was a paper that found that artificial intelligence, when it was given the names and faces of men and women, this particular artificial intelligence model was more often likely to associate a computer programmer with being a male and a homemaker with being a woman, expressing the bias that women are not computer programmers, for example. In addition, and this is a story that was in the news about the Google algorithm that was in Google Photos. And so, in that particular instance, the algorithm incorrectly identified two Black people as gorillas instead of humans. And so this generated quite an uproar. And one of the rationales Google gave for this error was that the algorithm was not given enough data on non-white people to identify correctly that the image was an image of people and not of an animal. So we know that AI has issues and problems with bias. Second, with respect to AI assisted inventions and AI inventors, uh, we think that the AI inventions have the potential to crowd out human inventors. And this could have even a more outsized impact on underrepresented innovators. So, first, let's talk about AI assisted examination and accessibility. So currently, AI is not directly used in patent examination, but the USPTO is exploring ways in which it can use computer tools and models to aid in patent examination. And for example, four ways in which it's attempting to use computer models to assist is to create a pre-search report for its patent examiners before they examine a patent application, assist examiners in making broad or more accurate queries when they search for prior art, um, automating documentation to speed up examiners, and also classifying patents using AI models and automated models to put patents in particular classifications so they can be routed to the correct examiner. So in its request for comments, the USPTO inquired about using AI for searching and examination. Uh, Now, why is this troubling, or why should we care about this? Well, there was a recent study done by two business school professors that looked at the disparities in patent examination along gender lines. And what this study found essentially was that women were treated differently. Women patent applications were treated differently. I should say, patent applications where women were named as inventors was treated differently than male inventor patent applications. And three of the most alarming takeaways from the study were that patents with women inventors were more likely to be rejected. Uh, a smaller fraction of their claims were allowed, and we know that uh, a smaller fraction of the claims means that could mean that the claim scope or the patent scope of the patent is less impactful um, when it comes time to enforce that patent. And then finally, more words were added to the claims during prosecution. Again, the impact of this is that it limits the claim scope. And so we have concrete evidence that is already some bias going in to the patent system without artificial intelligence. And so I do worry about when artificial intelligence eventually is used in patent examination, whether or not more bias will occur, and how, what do we do? What do we want to do to combat that? And so there are some best practices. We've known about AI bias for a long time, and we've known about best practices that have been implemented in other domains to combat bias. So the first is to fully recognize and acknowledge that AI models are in fact created by humans, and the characteristics of humans that create an AI model play a critical role in how well that model will perform and what results it will come up with. So Kathy O'Neill, who is the author of a book called Weapons of Mass Destruction, proposes that AI creators should be governed by a set of principles similar to that of a professional oath. And so this does a number of things. First, it establishes the human creator as the responsible party, and it provides creators with a sense of duty and purpose. Second, we have to worry about proxies. And so proxies for early AI models is a big problem. So for example, we know of AI models that have used zip codes as a proxy for race of an individual. There also have been some reports of insurance AI models that use credit scores as a proxy for safe driving practices. And so we need to worry about what information, the information that is exposed or given during patent examination. We should worry about whether or not that information is going to be used as a proxy for something else. So, for example, uh, when you file a patent application, once you file over a certain amount of claims, you have to pay an additional fee to the patent office. And so one could imagine that the number of claims in a patent application could be used as a proxy for the financial resources of the applicant to determine whether or not the applicant has the capability to commercialize the patent. And so with respect to proxies, the information that is exchanged during patent application really should only be used to determine whether that application meets the statutory requirements. It should not be used as a proxy for other determinations. Another proposal is to require applicant consent. In other words, if an applicant knows or thinks that if an applicant is going to be subject to AI examination, they should give their consent to that, at least in the early stages when this is first implemented and rolled out. And two things that consent, two objectives that consent um, uh, acquires is that one, it encourages transparency. And outside observers, transparency is important because outside observers should know what AI is doing and how an AI model works. It also is important because it allows stakeholders to identify problematic models and correct those models or challenge the process that those models use. And when an outcome seems wrong or unfair, it's non-transparent AI models that raise a number of procedural concerns. And we've seen those concerns play out in the criminal law context. More importantly, for repeat players, which there are a number of repeat players in the patent system, for repeat players, without transparency, there's no way to know how to adjust your strategy to arrive at a successful outcome in the future. So transparency is an important pillar with respect to consent. Also, when we ask for applicant consent, this is also providing notice. And what that means is that applicants are aware that their application is subjected to artificial intelligence examination. And this is commensurate with what's happening now. When you file a patent application and it gets examined, you know who the examiner is. In addition, artificial intelligence systems used to examine patent applications should be subject to administrative and legal review. Uh, the problem that we see play out in public time and time again with artificial intelligence models is that they make a mistake, and then the owner of the model apologizes for that mistake. They then go off and say, we don't know what the AI did. We don't really understand how it arrived at this result that is harmful or offensive, but we'll go and fix the problem. And generally, this problem is exacerbated by black box systems. And I spoke about this earlier. These are AI models where we don't really know how the AI model works, either because the owner or the creator has decided to keep that a secret, or the owner or creator doesn't know themselves how the model exactly works. And so, with respect to uh, patent prosecution is not a black box system, and neither should be AI assisted examination. AI users and its creators should be held accountable when it makes mistakes, and those mistakes, again, should be subject to procedural and legal review and challenge where necessary. Another best practice is implementing human in the loop systems. And there's a vast literature of failings of human only systems. Humans are imperfect, we make mistakes, and AI models have several advantages over clearly human systems, and this much is true. AI doesn't get tired. AI, if it has an unlimited power source, it doesn't want to take a vacation, it doesn't get sick. AI doesn't demand a raise, at least not now. However, as we have seen, an AI model may not be ideal because of the bias that it can introduce into the system. And so a best practice is to implement instead human in the loop systems. And this is where a human works alongside an AI. And there's a body of literature in medicine regarding surgery, in manufacturing, where they have found that human in the loop systems lead to better outcomes. In particular, humans have the ability to identify tricky edge cases or boundary cases and intervene and prevent the AI from making a harmful or disastrous result. The artificial intelligence system that the USPTO chooses needs to provide clear outcomes. Uh, They need to define what success is. In my view, success would be awarding a patent to an invention that meets all the statutory requirements, and the AI model needs to produce actionable conclusions. Actionable conclusions are important because it allows repeat users and inventors to confirm their behavior or adjust their patenting strategy and behavior to obtain a successful outcome in the future. So those are the best practices with related to AI assisted examination. And with the time I have left, I want to turn to uh, what might be the impact of having AI inventors on patent accessibility. And so first we know that the patent office, the journey to the patent office is a race. And so it's easy to see that artificial intelligence, for the reasons I mentioned earlier, artificial intelligence may in fact have some advantages in this race because it doesn't get tired. Um, it doesn't take days off, etc. And so AI would seem to have some advantages, at least from an endurance standpoint. We also know that AI is not going to stick to just complex inventions in the computer science realm. For example, the Artificial Inventor Project recently filed two patent applications that it claimed were wholly generated by AI. The first was a container system that used fractals, and the fractals help the containers stack upon each other in a easier manner. And then the second invention, which was also a little disturbing, was a neural flame. And this invention created or emitted a light that humans couldn't ignore. And so we know that AI is not going to stick to complex inventions. And again, this has the potential to crowd out uh, human innovators and also underrepresented innovators. Luckily, currently the law does not recognize AI as an inventor. However, there is a growing recognition that AI is a useful tool for creative activity. So we had a interesting copyright case in China recently, where the Chinese court held that a article generated by AI was eligible for copyright in China. The Chinese court said that the creative team behind Dreamwriter, which is the artificial intelligence that generated the article, that creative team created the content, and Dreamwriter was the tool that generated the actual writing, and that actual writing was protectable under copyright. And we've seen, for example, AI such as IBM Watson mature from just simply beating humans at Jeopardy to assisting people in healthcare and financial research. And patent policy can encourage the creation of better AI tools, encourage transparency, and what Professor Artie Rai refers to as minimum explainability. So the last point I want to make before I close is that I don't think it's all doom and gloom with respect to AI. I think AI is a tool like anything else, and a tool that can be used to actually solve the accessibility problem. The USPTO has several current outreach efforts. These include reduced fees for micro entities. These are small solo enterprises, pro se assistance, a patent pro bono program. In addition, there are several patent and trademark clinics based inside US law schools. And so all of these inventor and entrepreneur resources exist, and artificial intelligence could be a helpful way to augment these services. Um, we've seen tremendous advances in the delivery of legal services using AI. There has been some pushback from the bar about these services and whether they facilitate the under authorized practice of law. But I think social justice concerns and legal access concerns may win that argument. And so this is an example. For example, the USPTO has an IP awareness tool that provides the user with basic guidance on how to go about or how to begin thinking about how to protect their intellectual property. So to close, if we're going to use AI in the patent system, let's provide AI tools for the public as well. Let's use best practices to make sure that the artificial intelligence systems that we implement aren't biased and don't further harm underrepresented innovators. Instead, let's provide these underrepresented innovators with the tools that they need to continue to invent and continue to make the United States a destination for patenting and innovators. So thank you for your attention. I'll stop now, and I think we'll start with the Q&A. So I can't hear you. Sorry.
Thank you very much. It's always helpful when people remind me of that. All right. So first of all, thank you, Professor Robinson. Um, we're now going to open it up for questions. So if you've got a question, just go ahead and type it into the Q&A function in the Zoom webinar. And if it's a short question, I'll just read it. If it's a longer question, I'll unmute you so you can ask the question yourself. I have a couple questions already. So the first one is from Shubha Ghosh, which is just, what is the source of the ethnicity and gender data that you cited?
Yes. So I know Shuba. So the first study was a information technology and innovation fund study. That was a 2016 study. I'm happy to provide you with a link to that. So that was the source of the ethnicity and gender data that I presented in the beginning of the talk. And then more recently, there's more gender data that's available on the USPTO website. If you go to the page where USPTO initiatives under expansion of innovation, they have some gender statistics that they recently collected there.
Okay, so the next question, I have one from James O. Wilson. James, I've unmuted you, so if you can go ahead and talk, that would be, ask your question, that would be great.
Good afternoon. Can you hear me?
Yes.
Fantastic. So I see your analysis and your subject matter. I actually work at the United States Patent and Trademark Office, and I have been an examiner, or was an examiner, for 28 years. And in my examination, my focus was never, ever who the inventor was, ever. It was always about the claims, the specification, and the disclosure, what's before me. So my question to you is there any thought, or could there be some correlation between the prosecutorial diligence on the outside of attorneys who are actually representing women and minorities with regard to how they prosecute cases before the USPTO?
Yeah, so thank you for your question, and it's great to have an examiner actually involved in the discussion. I agree with you. I think that I think what your question is getting at is, could it be the patent attorney or the patent agent in their representation of these underrepresented innovators? Could it be bias baked in from the patent attorney side? And I think that's a fair question. I don't know the answer to that, but what I will say is I think it might be likely. So there's another interesting study that I didn't have time to discuss in the talk, but it actually looks at patent examiners at the USPTO, and it looks at what is the difference between, or seeks to look at what is the difference between women patent examiners and male patent examiners. And one of the first conclusions, which I'm sure you know already, James, is that women patent examiners tend to be clustered around a few patent areas. So one, for example, in the biotech area, biology, chemistry, we see a greater number of women patent examiners in that area. And interestingly enough, what this study found was that by its measure, female patent examiners were more diligent, more efficient than male patent examiners. And so I don't know that this study has been replicated by anyone, but what I would say is, if certainly if there are gender differences that we can detect on the examination side, then I think it would be foolish not to also look at the prosecutorial side to say, maybe there are some differences on that side as well. Maybe there's some biases on that side as well that we need to look at and need to address.
Okay, our next question is from Connor Williams. Connor, you can unmute yourself and go ahead and ask your question.
Okay, I'm just a student at the University of Iowa, looking to go into patent law. And what I'm wondering is there anything we can do to have a say in whether or not the USPTO will use AI to improve their patent examination processes? Or is this even a choice that we have as the public to be able to have a say in? Or will the USPTO inevitably use it if they so choose?
Yeah, Connor, thank you. Thank you very much for your question. So the answer to that is the public does have a say. So the USPTO has issued, in 2019, they issued a request for comments on artificial intelligence. And a number of the questions that I seek to address in my research were posed by the USPTO in this request for comments. I understand that they have issued a second request for comments along the same lines, asking more information, asking the public's opinion about how it should look at and how it should use artificial intelligence. As far as will it use it or not, I think it's inevitable that in some instances it will use artificial intelligence. And the reason I say that is Director Iancu in his January 2019 speech seemed to indicate that artificial intelligence, if the USPTO was able to use artificial intelligence, it would be a competitive advantage for the USPTO and for the country, right? And so the USPTO is looking at artificial intelligence as a way to make itself more efficient, more accurate. And so I do think it's inevitable that in some way, artificial intelligence will be used in the patent examination process. But to your point, and to answer your question, the public can give the USPTO input.
And for those of you who haven't already seen it, Professor Robinson also has a draft article up on SSRN. So if you'd like to dig more into some of the questions that he talks about here and some of the issues, I recommend you take a look at that article. Keith, what's the name of the article again?
So the article, the current title on SSRN is Access to the Patent System. I'm going to add artificial intelligence in the title so it's more descriptive. But I will, before we end, I will put a link to the article in the chat.
Great, thanks a lot. So we've got one more question. We have time for one more question. Professor Osei Tutu, let me just allow you to talk real quick and you can ask your question.
Can you hear me now?
Yes,
we can.
Hey, Keith, it's Jan. How are you doing? Hi, Jason. Okay, thanks. Great presentation. Really quick question. I apologize in advance if my background gets loud. I was wondering, and this ties into another question that was already asked, but how would you respond to someone who suggests that it's not really about gender or racial bias, but that there are other factors that come into play, like whether it's drafting practices or the corporatization of, IP in general? Thank you.
Thank you. Yeah, so I think we've seen this in other domains as well, where you would say, well, there are a number of factors at work, and so what I really am trying to accomplish with the paper and with the project is to make sure that we don't turn a blind eye to the potential of AI bias and try to ignore this problem and try to address the other problems, because I think we've seen in other domains, whether it be insurance, housing, or criminal law, humans trust artificial intelligence systems. In some instances, they are overly trustworthy. In some circles, this has been referred to as AI enthusiasm or techno-chauvinism. And so we just want to be careful that the artificial intelligence systems that we use are ones that that are more trustworthy. And one way we can do that is to implement the best practices that I discussed in the talk.
Great. Well, we're out of time, so I just want to thank Professor Robinson one last time, and thank all of you for joining us. We'll have a copy of the talk posted up on the IBL Center's YouTube channel, so if you'd like to watch it again or share it with others, you can do that. And I hope you can join us for our next talk. Our next speaker will be on September 24th, Professor Daniel Schwartz from the University of Minnesota will be talking about artificial intelligence, algorithms, and insurance law. So I hope you can join us then. Thank you all.